ओ,
Yes, Mr. Parveen.
Yes, sir. Good evening, sir.
हाँ, गुड इवनिंग कहते हैं मिस्टर परवीन. हाउ आर यू?
Fine, fine, sir. Fine.
हाउ इज वेदर इन दिल्ली?
Better,
बेटर.
better, better.
बेटर, मच बेटर है. तो नाउ नॉट दैट ग्रेट.
Hmm.
सर नमस्कार।
सर नमस्कार.
नमस्कार प्रधान साहब, कैसे हैं?
बहुत बढ़िया सर, एकदम फर्स्ट क्लास। ऑल वेल, नाइस टू सी यू
ऑल
सर।
वेल. बस बढ़िया है, हम भी. सब
Great.
भगवान की बड़ी कृपा है.
वेरी गुड सर।
बॉम्बे आना नहीं होता आपका? आके निकल जाते हैं या?
बस सर आना होता तो वो सुबह शाम का होता बस सर।
अच्छा. यूं ही सुबह हुई, यूं ही शाम हुई, जिंदगी यूं ही तमाम हुई.
तमाम हुई। अच्छा है ना सर, हंसते खेलते सब कुछ कट जाए।
हाँ, ये तो बात ही. दैट इज देयर. ये हमारा अब आया फोटो पूरा. मैं सोचूं हमारा पूरा क्यों नहीं आ रहा, जरा स्क्रीन गड़बड़ थी. अब ठीक हुई.
प्रवीण जी, आपके पीछे से आरती आ रही है क्या?
हाँ सर.
आरती की आवाज आपके पीछे से आ रही है?
हाँ जी, हाँ जी.
अच्छा
वो भजन चल रहा है सर.
अच्छा। हाँ तो समय तो भजन संध्या का है, आप भजन कर देखो।
अब यहाँ से भी आने लगेगी. आप आ जाइए, ऊपर चाबी दे जाइए.
ज्वाइन कर लिया.
Mange, dudu mange, dudu mange, dudu mange.
वेलकम रेशमा जी. नमस्कार.
नमस्ते, गुड इवनिंग.
जैन साहब, गुड इवनिंग.
थैंक यू सर. फाइन। आप?
कौशिक।
क्या मनीषा जी भी आ गई हैं क्या? हाँ
या सर।
मनीषा जी नमस्कार।
नमस्कार सर। जी मैं यही हूँ।
आप किसके लिए वेट कर रहे हैं फिर परवीन जी?
चल शुरू करते हैं, आप जैसा आदेश दें।
क्योंकि आई थिंक बहुत लोग नहीं आए अभी तो। 7।
कोई बात नहीं, एक बार शुरू करते हैं ना।
हाँ, दैट्स बेटर। लेट्स
बेटर ना?
लेट्स स्टार्ट। आप शुरू कर दीजिए कि नौ 6 minutes are already passed.
Yes, yes. Now, welcome to all of you. And first of all, I want to say कि सब अपना अपना इंट्रोडक्शन सेल्फ इंट्रोडक्शन के रूप में देंगे, राइट सर, ताकि ज्यादा टाइम ना लगे।
हाँ, नहीं नहीं नहीं, बिल्कुल ठीक बात है। बेहतर
एंड
इंट्रोडक्शन पे टाइम ना वेस्ट हो। 6 मिनट ऑलरेडी निकल गए।
राइट राइट सर। तो today's topic, my opinion is that today's topic is perfect transaction, avoidance transaction. Apart from COC code of conduct and delay delay in approving of CPO hours by our IPA. So on account of perfect transaction is the main issue, or key issue is non-cooperation by CD and creditors. And second one is litigations, delay in litigations by executing authority on account
यस।
of delay. And third one is information is mostly not available for reporting to executing authority on account of perfect transactions. And other one is not protection to IRP, RPO, liquidator for from SCN or enforcement agencies. Right, sir? And other one is no incentives to RPs on account of volume of work which you have done. So this is the whole work, and Nipun Singh Viji also coming shortly. So they will start session as a session chairman person. And now one by one, you may introduce yourself. So then first is, sir, yourself, sir.
नहीं नहीं नहीं, इट्स ग्रेट। इट्स ए रियली ग्रेट अपॉर्चुनिटी
Sir,
अगेन टू डू।
only in a short one
सिर्फ
paragraph,
ग्रेट
sir.
अपॉर्चुनिटी टू बी पार्ट ऑफ द प्रोसेस ऑफ शेयरिंग नॉलेज, लर्निंग नॉलेज as it on the bench and off the bench
Okay, sir, thank you.
nowadays.
And Manisha ji, please.
Thank you so much for having me. As sir has said, I would love to know and discuss as to what can be done to solve these issues. They're very relevant issues, and I hope I'll be able to contribute something to this.
Thank you, Manisha ji. And Reshma ji, please. Unmute yourself. Yes, sir,
Thank
please. Yes.
Thank you for inviting me. And I am here, first time I am here. I am Reshma Mittal, founder partner of RR Insolvency Professionals LLP, and I am in practice since last 28 years in the CA profession, and handle 10 to 15 CIRP and liquidation cases, and handling the personal insolvency cases also.
Thank you, madam. Sanjeev Pandey ji, please. Sir. Yeah. Please, sir.
Yes, sir. Good evening. Good evening,
Good
everyone.
evening. Good evening.
Thank you for having me here. So, I think many people know me. So, I am a retired banker, now an insolvency professional, also a researcher on IBC. I'm working with CAFRA, which is the research wing of RBI, on IBC related issues. And I'm also a consultant on insolvency and bankruptcy and restructuring with a law firm called DSK Legal. So glad to be here with you, and I'm happy to listen and learn. Yeah, thank you.
Thank you, sir. Thank you. Sir, Madan, sir, please.
Good evening, everybody. GP Madan this side. I'm an insolvency professional and a corporate lawyer. And more than that, I'm a student of law. present here to learn from everybody who is present here.
Okay, thank you. And our president of IAPA, Manoj Anandji, and vice chairperson of our committee, Manoj Anandji, please.
Yeah, thank you, Mr. Jain. Thank you very much. I really appreciate your efforts that you've been able to collect so many people at one platform, and all very, very, very senior people. But at the same time, this gives me yeah, an opportunity of learning from everybody. And as far as perfect transaction is concerned, it has been in dispute since beginning, and it will remain in dispute. Even in fact, जो एक meditation का भी आया, उसके अंदर भी ये कहा गया है कि जो ये पीछे लास्ट वीक मेडिटेशन के ऊपर जो आया था उसमें भी ये कहा गया है कि हम परफेक्ट ट्रांजैक्शंस को मेडिटेशन से बाहर रखेंगे।
मीडिएशन से मनोज जी, मेडिटेशन मत को मेडिटेट करने तो मुश्किल हो जाएगी, मीडिएशन से
चलिए या मीडिएटर का कह लीजिए। इट्स सर वकील साहब जब भी है ना कोई बात करो, कोई ना कोई ढूंढ लेते हैं उसमें से तुलका एज ए प्रोविजो एज ए सब सेक्शन, पता नहीं सर, हैट्स ऑफ टू यू, आप तो मेरे वैसे ही गुरु हो। यू नो आई मस्ट शेयर एवरीबॉडी देयर दैट आई एम एन इंसॉल्वेंसी प्रोफेशनल ओनली बिकॉज ऑफ मिस्टर मदान। आई हर्ड हिम इन वन VVSS seminar and then thought of giving my exam and passed that exam. In any case, I've taken a lot of time. I'm really obliged for learning. कभी कभार होता है ना कि किसी एक सेमिनार में आप एक आधी लाइन ही पकड़ लेते हो and after that you start doing it. I'm always obliged for that. Thank you very much. I pass on the mic to the others now, please.
And sir, thank you, Manoj ji, thank you. And Mr. Vishal Singh ji, please. Vishal ji. No, I think he is not here. Vishal Singh ji, please. And thereafter, Rashmi Chacharia ji, please. He is also our founder member.
Good evening, everyone. Thanks, Praveen ji. I'm Rashmi Chacharia. I'm insolvency professional from Kolkata. And I'm glad that Praveen ji is taking so much pain, and matlab, because of him, matlab, we all are here, and I'm looking forward to listen to everyone. Thank you.
Thank you, Rashmi ji. And thereafter, Anuradha Vishani ji, please. Anuradha ji, please. No. And Anuradha Gupta ji. I think she is not here. Now I request to Manoj Anand ji, please proceed further. Manoj ji. Manoj Anand ji.
Yeah, I'm doing.
Please carry on.
Sir, I'm not the speaker today. Let that
preference transaction, then undervalued, followed by fraudulent and extraordinary transactions. One by one, right, sir?
Yeah. Jain Sahab, actually today I'm not the speaker. I'm part of the host. Let some speaker be invited for that because I can't take their place. In earlier webinars, I was the speaker, so I do it. So please ask some speaker to be there because that my humble submission to you is that. Please.
Sir, you carry on, sir. On behalf of JIPA, please.
Okay. This perfect transaction is also, the full form of perfect transaction is known to everybody, is also known as the avoidance transaction. And I remember that when, recently when we represented India in our Singapore, the IBC webinar also on behalf of our institute, there also we discussed it when the forensic audit was recently introduced. और परफेक्ट ट्रांजैक्शन जो है हमारी 45, 46 ऑनवर्ड्स 47, 49, 60 सेक्शंस के अंदर कवर होती है। तो earlier as far as our NCLT and other the platforms are concerned, तो इसके अंदर ज़्यादा ध्यान नहीं दिया जा रहा था। But for the last, I think the 6 or 7 months ago, when this matter reached to, in one of the particular case, reached to the higher authorities, recovery was made. And it's basically, I treat any recovery in the perfect transaction as a hidden treason. And the hidden teaser mean that this teaser can be from anything small to anything big, but it can contribute a lot as जो हमारा एक IBC का objective है, maximization of assets value. So if we as an IP, with the help of our all advocates, is able to there is always anything, because any company which goes into the IBC always have something hidden as far as perfect transactions are concerned. Only thing is we need to extract it. And when we need to extract it, for that, we need to put a lot of efforts, not only in our accounting records, but information which we do gather, other than from the financial records also. We need to knock for that therein. And also, then placing it before NCLT, Honorable NCLT, that this recovery is to be made from the person who has basically withdrawn the money from their end. And based on that, now I request that let my other speakers take section wise each of the each part of the perfect transaction, like preferential, undervalued, fraudulent, and exhaustionate transaction, so that we all get enlightened with it. So Praveenji, this is I've started with this thing. Please pass on the baton to speakers now.
Rashmi ji, please carry on. Hello, Rashmi ji. Are you hearing me? There is some, I think, disturbance there. Hello.
Sir, we can, we can request Madan sir.
Yes, Rashmi ji,
can
please.
carry on.
Yes, now I would request Madan sir.
Yes.
Sir, please start your deliberations, sir. Thank you.
Which
Madan
one?
sir. Madan
Yes,
sir, I will request Madan sir to please start his
See,
deliberations.
I don't know whether the organizers designed this program and shared the structure of the program or not with the faculty, because I was conveyed day before yesterday only, or yesterday, I don't remember, that whether I should be panelist, and I'm here as panelist. So we have not prepared any PPT. I have not prepared any section by section.
Sir, you can take it as, sir, you can share this.
But yes, the issues I can.
Sir, you have no need to any PPT or other material.
No, okay. The issues, some basic issues. We'll go through in details of the main issues, but basic issues which according to me are as on date. Number one, you said, Praveenji, that there were issues at the delay on the part of the adjudicating authority. This I say at every place. According to me, there is no delay on the part of adjudicating authority.
Warranty.
रश्मि जी सबको म्यूट कर दीजिए, ऐसे डिस्टर्बेंस रहेगी बीच में.
Okay, thank you. In our last event also, and Manisha is witness to that, I said in our PhD Chamber of Commerce event also, and normally I say that is NCLT, the adjudicating authority, National Compliance Tribunal. NCLT was constituted under the Companies Act 2013 for the purposes of Companies Act 2013. Now, later on in 2016, IBC became reality. So IBC said, okay, IBC required an adjudicating authority for corporate entities and non-corporate entities. For non-corporate entities, they said, okay, DRT will be there. And for corporate entities, because DRT was in existence. And for corporate entities, ab unhone dhunda what is there in existence. Okay, NCLT is there. Okay, let's give this authority to NCLT. And NCLT was named as adjudicating authority. Now, since the day the NCLT has become adjudicating authority, all Companies Act cases are on the back foot. Whether it's a merger or whether the O&M or even reduction of capital, even such or any corporate restructuring activity, they are on the back foot. because under IBC time is the essence. And then we saw COVID. And post-COVID, we saw that bench strength was reduced to not even 50% of the total strength. So if we do not have NCLT members, whether judicial or technical, if we do not have adequate infrastructure, then in such a scenario, if we expect that our adjudicating authority will decide all the cases pending before it in a speedy manner, I think we are expecting moon. However, now the position is, I request all those members who are joining, please mute yourself.
Kudu? Kudu? हाँ? बिल्कुल कहाँ पर
I think organizer who has the the power to mute everybody, they should mute. Otherwise, we'll be missing listening to the speakers.
ये ऐसी गलतियां जब कोर्ट में होते हैं तो क्यों नहीं होती हैं? I never appeared in the court. Okay. Mr. Indraj Saini, please mute yourself. Mr. S.K. Agarwal, please mute yourself. Okay. But now what we have witnessed recently, that almost entire bench strength is there. But the issue before adjudicating authority is to give priority to resolution plans or to avoidance transaction application. I think it's a conscious call on the part of adjudicating authority that first of all, we have to deal with the resolution plan applications. And no resolution plan application consideration should be delayed simply because the avoidance application is pending before it. That is why all NCLT benches have decided that first of all, we'll clear the resolution plan applications, and then later on, whenever time permits, we will deal with all these PUFE applications. And that is the reason, friends, I tell you that if you have observed recently the court orders, in the month of February itself, I think around 15 to 20 resolution plans have been approved by various benches of adjudicating authority. And that is the priority for NCLT. PUFE, they will go through the PUFE application, no doubt about that. But in PUFE application, friends, we, the resolution professionals, whenever we file an application, do we ever give attention to this fact that how many respondents are there in one application? In some application, I see that 20, 30, 40, 50, 70 respondents, 100 respondents. So let's take an average figure of 40 to 50 respondents. If 50 respondents are there and you file an application, the notice is issued. First of all, till the time all 50 replies are there, case cannot move. Then the resolution professional will decide, okay, I need to file a rejoinder in all those replies. And after rejoinder, then the turn will come for arguments. In the meantime, somebody will file some affidavits. One of the lawyers will seek adjournment, or somebody would like to place additional documents on record. It will take, I tell you, years together to complete the pleadings. So unless the pleadings are complete, argument cannot happen. These applications cannot be decided. And let me tell you, heaven is not going to fall. In majority of these applications, there is hardly anything to be recovered. That is the practical reality. Hardly anything is to be recovered. So let's not expect adjudicating authority to waste its time in deciding transaction application at the cost of resolution plans. If I am there, if I have to decide, I'll give priority to resolution plan rather than giving my time to avoidance application. And then further, friends, the three issues which are there, once a resolution plan is approved, after that, who will pursue these avoidance applications? Will it be RP? Will it be SRA? Will it be member of COC? Who will decide? Who will pursue? I think this conscious call should be taken at the time of approval of the plan by the COC. Friends, please mute yourself. The COC at that point of time should decide, and it should be, according to me, part of the resolution plan, that after approval of the plan, who is going to pursue these applications. Number one. Number two, who is going to bear the cost, the litigation cost of pursuing this adjudicated, this PUFE transactions application. And third, who is going to be the beneficiary? If anything is recovered later on, who is going to be the beneficiary? All these things, according to me, should be decided at the time of consideration of the resolution plan, and all RPs must give their proper attention to this thing, whether all these things are part of the resolution plan which is being approved by the committee of creditors or not. And if not, he should ensure that all these things are there later. Otherwise, later on, if all these three issues are decided at the time of approval of the plan, I tell you, it will reduce the litigation at later stage. Now, who is going to pursue this application? Let me give it a different dimension to this. This application is filed, say, by IRP or RP or liquidator. Actually, here also is a point of debate whether RP or liquidator can file these applications under all the sections. Can liquidator is also equally entitled to file this application as the resolution professional is? Now, looking at the current scenario, suppose a company goes into liquidation, and as per the latest communication of IBBI to adjudicating authority, so that's a communication only, but that is being treated as law by adjudicating authority. That communication is nothing but a recommendatory communication. It's recommendatory in nature, that if the company, if there is no resolution plan, a company goes into liquidation, then in that scenario, resolution profession shall not be appointed liquidator. If you ask me personally, I am against this communication. If you read the language of that communication, it simply states that the RP is responsible if there is no resolution plan. How can RP be responsible for absence of any resolution plan? Is it a failure of RP? My answer is no. But IBBI has considered through this communication that there is no resolution plan. It is a total failure of the resolution professional. So therefore, such a resolution professional should not be appointed as liquidator. Now, a transaction application has been filed, a resolution professional. Now he is not there during liquidation. Liquidator is taken over. Liquidator does not know A to Z, A, B, C, D of this entire application. He'll have to go to the entire application, the content, the annexures. He doesn't know the basis of this. Even some of the COC members at this stage may be there or may not be there. Who is going to guide him? Nobody is there to guide him. So it becomes very difficult for a liquidator who has replaced the resolution professional to pursue these applications. Or I tell you, जिन लोगों के against application डाली जाती है ना, all those respondents are very happy if a company goes into liquidation and there is a different person as liquidator. They are very happy. They are very comfortable. Now nothing can be recovered from us. The other issue before me is that in majority of the cases, these applications are filed on the basis of transaction audit report or forensic audit report. Friends, please, whenever this report is received by you, please read this report thoroughly. And if you read this report thoroughly, I can tell you with conviction that you will never file this transaction application. Because this entire transaction audit report or forensic audit report is with so many observations. So many disclaimers are there. Even the transaction auditor, forensic auditor does not take responsibility of the correctness of this report, because he simply says that I have not received any information. And this report has been prepared on the basis of whatever available information was there or whatever information provided to me. If transaction auditor or forensic auditor himself is not having any conviction on the contents of the report, and you are filing this application on the basis of this report, and that is the only basis of your report, do you think that you are going to win in the before the adjudicating authority? Will there be positive order in your favor? My answer is big no. There will be only in exceptional cases you will get a favorable order. Otherwise, in all other cases, these applications are going to be dismissed if this application is on the basis of tar or far. It is sheer wastage of time, energy, and resources. The next issue which I have on this avoidance application is with respect to the latest judicial pronouncement by the Apex Court in case of applicability of Section 66. As per the latest judicial pronouncement, Section 66 application can be filed only against the directors or against those who are involved in the operations of this corporate debtor. Suppose if directors of the company have entered into some fraudulent transaction with some their relatives or friends or associate or anybody else, and if you make them respondents, certainly they cannot be made respondents. I have seen after this judicial pronouncement by Apex Court, some of the NCLT benches are themselves suo motu asking the resolution professional applicant to file a revised memo of parties. And whosoever is their director there, barring whosoever is responded there, barring directors, please remove all their names. And I tell you, in many of these companies, who are the respondents? Directors. And who are the directors? Lower level staff of the corporate debtor, they are directors. Because the original promoters have vanished. They made these junior employees as directors. Now, if you file these applications against the junior employees, are you going to recover anything? Not even a single penny is going to be recovered. I think IBBI Ministry of Corporate Affairs has to give a serious thought on the provisions, applicability of the provisions, and practical aspects of all these sections under which these applications are filed. These are my some of beginning observations. Now, house is open for us. Thank you.
Thank you, sir. Like you said, rightly said, ki matlab directors are lower level staffs. But right now, the provisions does not empower us to file against the erstwhile directors or the directors who were previously in the companies. Can we do that?
You try to do that. The other party is going to challenge it, and then you defend your decision. Now this will be another litigation. And who can be made respondent? This is a debatable issue. All those erstwhile directors are going to challenge that I cannot be made a party. So first of all, the court has to decide whether they can be made respondents or not. Transaction application number to baad mein aayega. Pehle is issue ko discussion hoga that whether the memo of parties is right or not, perfect or not.
Now I'll invite Manisha ji, and Manisha,
Manisha also, I can see Manisha also wants to speak on this particular issue.
Yeah. No, I think sir has spoken very well on the topic, and he's much more on it. So I just wanted to add to what Mr. Madan was saying with regards to how to get information from the corporate data, because that's the problem which most of the IPs and resolution professionals are facing. As to they have the transaction report, they have the forensics report, but what to do with it? Apart from the fact that what Mr. Madan has said, that you have to go through it and read it very properly to first form an opinion, which you need to file before the court in the time given. But I have a suggestion, and I'm a bit forward-looking and solution-oriented in my approach to litigation and to life in general. I believe that a due diligence conducted apart from the audit reports, both the audit reports, which are more numerical and transactional basis, I feel that a due diligence from a legal perspective of how the case can be filed and made out under all these sections, and especially the fraudulent transaction section, that will really assist the court, and it will also sort of do half the job for all of us, thereby reducing the delay in the court. It might also help the IPs to form their opinions, whether they are filing these applications, whether they have any substance. And that due diligence now ties back to how do we get information from the corporate debtors or from the promoters of the company. This is something that I had said earlier also, that there has to be some sort of a mechanism put into place where these companies which are about to become NPA, or they already know that they sort of are becoming NPA or going into CIRP or whatever, are forced to give information to some sort of a custodian of records, how the ROCs for companies under the Companies Act. Now that information should ideally be all the information which an IP might need. Now, the IBBI is one of the people or one of the statutory bodies who can actually look into this and do the needful for this. And what my proposal usually is for this purpose is a company knows its net worth getting eroded or it becoming an NPA much in advance. And that is an observation also made by the Apex Code, that once you sort of know that you're going to get into a CIRP, or you are about to get into CIRP, or you are eventually going to get into a CIRP, you better not be doing these transactions under 43, 45, 40, 66 and all of those, right? Now, similarly, once you know that sort of inevitable situation is arising for your company, say at 50% net worth erosion, why not file some information which is needed or will be needed by the IP eventually? Similarly, at 100% also you file. Then, of course, you go into an NPA, or you go into, or the bankers are filing a Section 7 against you, or any financial creditor or an operational creditor. That kind of information might help at least ease this process in some way. I'm not saying it's a flawless process. Of course, there will be loopholes exploited and found. That is where the statutory bodies or bodies like DIPA will come in to sort of plug it as much as possible. But that is needed, because this cat and mouse game which one has to play with the promoters and with the corporate debtors has to be stopped somewhere and plugged somewhere. So that is one of my suggestions, that we have to have this information dealing situation to be sorted much in advance. Now the delay part, I think Mr. Madan has covered it. I don't think it's the fault of the courts. It's a long drawn process. The members are burdened with too much work and too many applications, too many things. So to say that the NCLT is delaying it, it's not right. We need to ease the process for the NCLT, where the lawyers, IPs have a role to play. The applications don't have enough information. It becomes a fact-finding process for the court. Sometimes the court is asking for additional affidavits to be filed, that, oh, give me this information, give me that information, to form an opinion whether this transaction is supposed to be set aside, or the clawback mechanism has to be put into place or not. So if we are not doing our jobs properly, we can't blame it on the judges to have decided and how they will decide all of these things. They are not the cause, and we are the cause, and that's the effect, the delay. Now, as far as the other things which Mr. Praveen Jain had said with regards to limited funds available to hire good auditors. Now, what is a good auditor is something which the CAs have to decide amongst themselves, because this problem arises with how to hire good lawyers also. So how we make our professionals worth the time and worth the money is something which cannot be a reason for hiring bad auditors. That, oh, I hired somebody for less money, so he was not good enough. As professionals, at least as lawyers, because that's the only qualification I have as of now, as a lawyer, I can say that it's unfortunate that, yes, there are lawyers who might be cheaper and who might not deliver that. But that's the problem of the professionals in one go. It's not the problem of the court or the person hiring that person. Money is an aspect which you decide for yourself, that what is your time worth. But whether you take 1 rupee or you take 1 lakh or you take 1 crore, you as a professional have to deliver the best. So good auditors at cheap rates is something which the professionals have to decide for themselves. I mean, this is what more or less I have to say right now till what Mr. Madan has covered. I'll try to chip in once I hear more opinions on these things.
Thank you, Manisha ji. I would like to, also, you have said that I would also like to welcome Ms. Mamta Binani and Mr. Nipun Singhvi. They have just joined it, and I believe Mr. Nipun Sanghvi is the chairman for the session. And Mr. Nipunji, were just discussing and heard about from Mr. Madan and Manisha ji, and like you said, Ms. Manisha ji, that you know, these things can be beforehand gathered, the informations. Like, but I think these informations are being gathered by the bankers as well. In this process of as they
I
are the
agree, but
lenders.
I also feel that the banker's process of auditing while the loans are pending is not as comprehensive how a lawyer does a due diligence. Believe me,
Yeah.
a secretarial audit and a legal due diligence is so comprehensive because the lawyer's reputation is on the line, and so is the company secretary's. So I would say a CS's secretarial audit along with the legal due diligence is a must, which should go along with these transactional and forensic audit reports.
Yeah, I think Mr. Sanjeev ji, aap isme you can throw some light because you are from the bankers side. So what can you matlab, you know, matlab can suggest, and then Mr. Nipun can take over the session. Sanjeev ji.
Yeah. Okay. Thanks, Madanji and Manisha ji. I think they gave a very good insight on this transaction. Madanji was spot on. He said that a vague report, because as I have also seen, most of the times the forensic or transaction audit reports, they don't conclude anything. They say we suspect this is a transaction. Suspect will not do. Basically, these 4 sections work under the goes towards the criminal law, application of criminal law against the parties. So you need a foolproof evidence there. It is not like a circumstantial evidence building. So that is the major failure of these transactions and any outcome out of these. And Manisha ji, I think, rightly pointed to the direction of twilight period when most of these transactions are done. One setback, I think, in that thinking is that already the time taken by the courts for admission of the CRP itself goes out of that twilight period. So transaction was done 2 years back, but court takes 2 years or 1 year to admit, so we lose that time. So there is some tweaking of law is required so that at least the date of filing should be treated as the look back period, start of look back period, from which they should look at this twilight period and look at the suspect transaction. I totally agree with Manisha ji that the problem of funds, because I have been sitting in many COC earlier as a member, now as an IP, and I also have been part of drafting code of conduct for COCs. So I have been through all this, and I know most of these COCs, especially where SBI is not there as a member, we have seen the tendency of the members is to cut costs, and they want to go for everybody who is the lowest, low L1. That is leading to a lot of substandard work in most of these matters. And if you give a transaction audit to a person and ask him to do it for 50,000, so he will deploy only his associate. He will not deploy his best mind for that audit. He will deploy some of his interns to do the audit and put up a report. If you pay him the market rates, obviously he will deploy some professionals from the market, his own people, good brains, and come out with a good report. It's as simple as that. You put more sugar and you got more sweet. That's it. But problem is that most of the COCs have this tendency to cut costs, and they are not agreeing other than L1 and leading to all these disasters. I have a different take on this, how to mitigate this problem, because this will remain. Whatever we do, the tendency of COCs is to like spend the least amount, and they are actually not expecting any recovery from these transactions. So as we know that the entire IBC is created on a marketing concept, like market concept. So you have to have a market for everything. Have a market for the asset, for the CD. The RP selection is through the market process. So everything is market oriented. Why not also apply those market for these transactions? So what I have been doing some research recently. So what we find that why not create a market for these transactions so that the interested party who is interested in buying this transaction is able to deploy money.
Sanjeev ji, please unmute yourself. You have got mute.
Okay,
Hello.
sorry. Yeah. So for having a good report, I think deep dive is required in this transaction, which requires investment of money on good auditors, and not only audit will do. See, the people who are committing these avoidance transactions, they are already advised by very good chartered accountants, very good lawyers. So they do a good money laundering. They do a very good cover up. And then they simply remove the books of account from the away from the RP, so that they don't share the information. These are two basic fundamental problems, and we have found no solution to this. Even you get a court order asking the promoters to share the documents, still they don't share. What can you do? And this is the easiest way of getting away from murder, by just removing the documents from the site. So this problem will remain if we keep on relying on these audit reports. We are not going to reach anywhere in these transactions. What I have found is that there are umpteen ways of looking at or getting information from the market, not only through audit, other means. Today, CBI, ED, so many other agencies, they do a lot of such audit, which is not exactly an audit of the books, but it is the scrutiny of the email, the mobile phone, SMS, lot of like what do you say, fingerprint or of the person on the electronics, the media. So that can lead to a lot of suggestion where the money trail is going. So I think better way to go after this transaction is to look for the money trail, where it has landed, create some proof or some evidence from that, and come to the court. Sir, now this is the how money has moved. This money is lying somewhere here, and where there is a fire, where is a smoke, there is a fire. So once you see the smoke, show the court that here is the smoke, then court will see the fire automatically. So I am in discussing with some of the agencies who are interested in these kind of transactions, this work, and if we and they are ready to invest a lot of money on this. So I think what we can do, not in the CRB stage, but at least in liquidation stage, when you can sell the assets by part, so these can be somehow sold or on the basis of sharing of profit or sharing of recovery or outright sale, so that some interested buyers can come in and they can put in money for legal fight, for collecting data, everything. So that is my take. Unless you do that, we are not reaching anywhere just based on the basis of transaction audit or the audit report. Thank you.
Thank you, Sanjeev ji. We have with us VK Gupta sir, Virendra Gupta sir ji. Sir, आप प्लीज बताइए कि delays in NCLT जो हो रहा है, मतलब how to, मतलब we can help, मतलब how to resolve that, मतलब उसमें क्या कर सकते हैं?
Mr. Madan has already spoken about the structural as well as manpower issues on that aspect, so I have got nothing substantial to add. The only thing is that once the resolution plan is approved, everyone loses interest. That's the issue, number one. And the implementation and money is substantial, and COC members know very clearly that nothing is going to come out of these applications. So they are not inclined based upon the reasons already specified here with disclaimers and lack of legal because the moment you as compared to preferential, undervalued or external transactions, fraudulent transactions have to meet the law nullified intent mens rea. Because fraud cannot be beyond that. So you lack that sort of killing evidence which can clinch the issue in the favor. Number one. Number two, what is happening that all these transactions to like June, when everyone is doing, unfortunately or fortunately, whatever we may say, the present setup is not creditors controlled regime. It is because it is financial creditors controlled regime. Operational creditors, if they get into CIRP, they lose everything. So what is happening, Mr. Sanjeev ji was rightly pointing out, and Manisha ji was also pointing out, on that front, there are two issues before us. Ek to now the present petitions which we have to address, how to applications can be disposed of and meaningful recovery can be done if possible in a time-bound manner. So that aspect we have already discussed. Now the question is coming, how to prevent, because insolvency is not is the regime is institutionalized now. It will be a part of the our socio-economic commercial system. So how to protect that? How to make a better system from the learnings of the past? So that is where the more and more things can happen. Particularly, if you recall, in this November 2023, RBI has issued a circular regarding KYC norms for politically exposed persons. So what they are doing, what they have advised every branch, that the persons, senior bureaucrats, MLAs, MPs, public servants, PSUs, they will have to fill that detail. And the transactions in their accounts as well as in the accounts of their associates, friends, will be monitored. So similar way, there should be a mechanism brought in by RBI in the for the business enterprises also, that the money which is going out, if it should be used for the purpose for it was sanctioned. Unfortunately, there have been a serious, now RBI has also amended forensic audit norms. So what happened? The RBI also failed in its supervisory role as far as monetary policy is part is one side where they have excelled. But on the supervision side, it's a sheer failure of RBI also, to be very frank. Banks top management, once they are disbursing the money, they know it, what is the position, where it is going. And the earliest point, twilight zone, maximum things happen. So these are the structural issues which will have to be resolved with the tracking through AI, more developed digital systems, and integration of GST and income tax and banking system. So when you can generate the data and extrapolate the data and get the things. Number one, for future, this is the proper way out. Another thing is coming, now COC. Role of COC is very important because as per section 26 and as held judicially, pending applications cannot bar the resolution or the liquidation. So what is happening, COC people, there was a code of conduct, draft code of conduct in August 21, I suppose, when the 32nd Standing Committee on Finance of the Lok Sabha raised the issue. Or February some came, but it has remained draft. Now the Delhi High Court has recently ordered that COC code of conduct should be devised by IBBI. So that is an important. Now the judiciary is feeling where the gaps are, right? How to fill those gaps. That's very important. The judiciary is taking a view. Now how to make the COC more accountable, because you are all practitioners. You know how the NCLT, after the SEBI Act, I would just digress. SEBI Act was the act where the SEBI is the regulator, is the adjudicator, is the legislator. So in 2004, in Clarient Chemicals case, Supreme Court observed it is such mixing of powers in one person, one institution, is violation of principle of doctrine of separation of powers. So based upon that, the IBC has been structured. Commercial process, COC, regulatory process and legislative delegated legislation, RBI, adjudication process is NCLT. The role of NCLT, and the Supreme Court has categorically stated that you cannot intervene into the wisdom of the COC. So most of the things we have to understand that what are the structural issues we devote, मतलब मर्ज बढ़ता गया, जो दवा करी उससे काम नहीं चलेगा. काम ये है कि we have to plug the loopholes where are happening. So that was another part.
Thank you, sir.
We have to, and now coming to that 66 section. So
Sir,
what the
one
Supreme...
second, sir. We'll also like to hear views from Mamta ji, Mamta Binani.
Yeah.
Ms. Binani, can you request you to, share the views on from the eyes of the RP and the liquidator
Yes, thank
about
you.
these transactions?
Thank you. Thank you so much to JIPA and to IPA both. And we must say that both of the organizations are doing very well. Thank you for this opportunity. If I look at it from RP angle, I wish to say that somewhere or the other, money always leaves its trail. Okay. What we somehow do is we kind of rely too much on the report. I have of late started understanding that it's also good to deep dive into it yourself, to understand the transactions yourself. We kind of just rely on whatever is coming to us, and we don't even have the patience to read the report because it's generally ranging from 500 to 800 pages because of the attachments, not because of the content of the report, but because of the attachments. And I'm just telling you from a very practical point of view. The RP generally, or the liquidator, goes to the last portion of the report where the conclusion is there. Okay, and many a times the conclusions are not there, but of late we've also started seeing that conclusions are there. Okay, be it meek or strong, but conclusions are generally there. And when we are also giving information, it's very important that we understand what is the information being asked. Normally, it's like a post office work that, the auditor is sending us an email, we kind of forward that email, and we become a conduit of receiving and sending emails. But apart from that, we also should get into that engaging conversation where we start asking the auditor as to why you need the information. And only with the reason is that you may have a perspective and you may be able to help the auditor with whatever you have in your store. Because for information memorandum, you anyways do a lot of homework to build the information memorandum. So that's number 2 point, that we should just not act as a conduit. We should also try and understand what is the info required and why is it being required. Third is, normally what I've seen is just 2 years info is just not good enough because of the time being taken in the NCLTs for admitting. I'm sure Mr. Madan must have touched on this issue because he always talks about it. And practically also we have seen that because of the time taken in the NCLT to admit the applications, be it section 9 or be it section 7, forget about section 10. Section 10 has somewhat become redundant. But section 7 and 9, the kind of time that we've seen it's being taken is almost ranging from 1.5 years to 2 years, if not more. Okay. And especially we've also seen that if a company is in CIRP and then getting into liquidation, we've seen a time lag of almost even 3 years in some cases. So then, the whole exercise of doing a look back period audit is actually lost. And sometimes we've also seen that it is planned in such a way so that the company is then going into it and nobody bothers about it. So therefore, the whole exercise of just doing it for 1 or 2 years loses its relevance. And I have seen that the audit is now ranging from 2 years to 10 years. It almost goes back to 10 years. Probably, let me just tell you this, everybody knows, but now the auditors have started seeing from the date of NPA, or, just be it 7 years, 10 years, or 12 years. So they just like to see which is the date of NPA. And say, for example, the NPA date is 2013. They'll start digging up the documents from 2012, because that's the timeline that they want to look at, because they understand that this is the time period when things have happened. Now, there's a huge challenge to get these documents from that time period, because the promoters start writing to you, why should I give you? It's only 2 years that's allowed. It's 1 year that is allowed. So getting those documents from a promoter for that look back period of 10 to 11 years is just like impossible. But then sometimes we have got hold of that tally data and you have the audited accounts. So from tally data, we try and just dig out what is the trail. And wherever there are doubts, we start writing and asking for remarks. Now, most of the time, we don't get those because that's the issue. So therefore, what you see is from practical point of view, that everything gets into the fraud slot. Because then fraud slot is one slot where the person who is in front of you has to prove that, hey, I am not fraudulent. And in all the other cases, the RP has to prove that it is an avoidance transaction. It fall under other than the fraud, because everywhere then you have to prove it within a square. If fraud is the only transaction, सामने वाले को prove करना पड़ता है. So that is, we don't like to put it in fraud unless we are sure, because a lot of mens rea comes into play. And all the lawyers who are sitting here, including all of the RPs, we know that how it becomes so difficult to kind of thrash that out in the courts. When you go to the court with a fraudulent transaction, it is most of the time the RP or the liquidator gets a thrash rather than the other side. Sometimes it is just said that these applications are mindlessly filed. There's no application of mind at all by the RP or the liquidator. But if you don't do it, then there's the other side of the coin, which says that why hasn't been done and there's something wrong, why, et cetera, et cetera. So we are in that, still that tightrope, but a lot of things have become better. Now, sometimes what happens is when the person who's going to defend that application has not understood at all the transaction, it becomes extremely difficult to first ask the advocate or brief the advocate, and also for that matter to run it yourself in the court. So it's extremely important that who we are, we also need to have a little more financial training. And I have somewhere felt that it is not difficult at all. Somewhere or the other, our mindset is just not that, we want to get deep into it, because we somewhere have thought to ourselves that this is not my cup of tea, or this is not my job. My job is just to get the report, file the application, and most of the times we don't even need to defend it, because it, by efflux of time, nowadays the NCLTs have started saying that you filed it so late, so it is getting dismissed therefore. So RP also feels my skin is saved, and the application also doesn't see the light of the day. So, but then the whole purpose of filing this application gets lost. But I think with the recent amendment in law, where it started saying that in RFRP, the treatment of PUF application has to be dealt with, that is actually giving some wings to it, because then it becomes kind of a addition to your recovery. And with the kind of bonuses that is being given to RPs and liquidators by way of value recovery, by way of some percentage that is given in the law, I think that's also motivating a lot of people to actually get into further recoveries. So there is a lot to say, but I have as a parting note for this point in time, I wish to say that the applications are very, very, very loosely drafted. It is not lucid. It has got no head and a tail. There's no linkage from one para to another. It is not even half-hearted. It is 10% heart and maybe 5% mind, which is put into the application. And therefore, as an applicant, as an RP who is the applicant, faces a lot of backlash, because ultimately it is your application. Whoever is drafted it or not drafted it is not important, but it's your home. So I think we should get indulged into it a little deeper and try to make sense of the application. Thank you.
Thank you, Dee. And with the latest amendment, I think now the RP is also to share the avoidance applications with the resolution applicants.
Yeah, it was always sold. It was always sold. I'm sorry, it was always spelled out, because in the VDR, etc. But anyways, law definitely helps.
Yeah. Now I'll also invite Miss Reshma Mittal. Reshma ji, now please give your views now.
And sorry, Reshma, just 1 minute. Nipun ji is fighting these cases in and out. I think he's quite an authority. It'll be quite nice to discuss Mr. Madan and Mr. Nipun after Reshma ji. Yeah, sure. Thank you. Thank you.
Yes, Reshma ji, please.
Yes. I am thankful to the JIPA and IPA for giving me this opportunity. And I have heard Madan ji, Manisha ji, and Mamta ji and Sanjeev ji. So first of all, I would like to raise my concern and thereafter would like to give my suggestions on that. So I am partly agreed with the Madanji and Manisha ji regarding the point that the NCLT, there is no fault of the NCLT. I differ on this part because I have seen that these applications are dealt with least priority and least urgency is given by the NCLT for these applications. These applications are not being decided upon with the requisite urgency or attention by most of the benches of the NCLT except a few. And it has been observed that there has been multiple hearings without substantive decisions. The reluctance to engage substantially with these applications does not only result in delay but potentially endangers the effectiveness and fairness that the code aims to promote. Right now, our courts are so busy that they don't have enough time to look closely at these complex applications. And because of that, they often put them at the bottom of the pile. Least priority is given to these applications. So my suggestion is that specialized benches should be established within the NCLT framework. These benches, such benches would focus on the adjudication of the avoidance transactions. And these benches should have mandate to look solely on these complex and technical matters. And these such type of the benches should comprise the members with expertise in financial and forensic analysis, along with the understanding of the code. These benches would not only respect the complexity of the avoidance transactions, but will ensure that they are given the priority and expert consideration that they rightfully deserve. This proposition aims not to bifurcate but to streamline, ensuring that the regular benches can focus on advancing the resolution, while the specialized benches can delve deeply into the intricate aspects of the avoidance transactions without the pressure of the overflowing dockets. And moreover, it is imperative that when these applications are brought before the tribunal, rightly said by the Mamta ji, that they should be comprehensive with the avoidance transactions clearly described and substantiated in support of the application. The straightforward depiction of these transactions will facilitate the adjudication of these applications by the adjudicators in rendering decisions that are just and timely. And I would like to share one of the live example. In my case, I have filed the 7 to 8 applications, only one is decided. Previous bench took 25 to 30 hearings. They have not decided these applications. And when this application was transferred to the another bench, they have decided it in 4 to 5 hearings. And they have ordered the 100 crore order to contribute by the ex-management, which this amount which they have chiffon off while managing the affairs of the company. So all of this is depend upon the NCLT benches only to decide these applications. Second thing, Sanjeev Pandey sir said that the look back period should be from the date of filing. I agree with them that the look back period should be widened, and Mamta ji also said. But if we say from the date of filing, what about the period between the date of filing and date of passing the order? So my suggestion is this look back period should be enhanced. In case of the non-related party, it should be at least 3 years. And for the non-related party, it should be 5 years. As the Mamta ji said that most of the banks are doing these audit from the date of the NPA. She has rightly said. But what happened about the preferential? We can't classify those transactions into the preferential. We know that this is the preferential, but we have to keep us restrictive for the 1 year only in case of the non-related parties. So the problem is of the preferential and undervalued transaction, and we have to classify all those transactions into the fraudulent category under section 66. So look back period should be more. And another concern is that one of the foremost challenges we RP face is the timeline prescribed in the Act. The Act says that RP are required to form an opinion within 75 days, determine the transaction within 115 days, and file an application with the adjudicating authority within 135 days. But this race against the time is compounded by the lack of access to or possession of the corporate debtors' books and records with the RP. My proposition is straightforward. These deadlines should commence from the day the suspended management provides the requisite records to the RP. And such a change would significantly enhance the efficacy and fairness of the process. Unless and until the RP had the record, how could he determine how he could form the opinion on the fraudulent transaction and how we can file the application in 135 days? Now coming to the 19.2 section, which is a toothless section, disappointing us and disappointingly ineffective section. Presently, the promoter and former management face little or to no repercussion for withholding the crucial records of the CD. No order is passed except the court says just to cooperate. They says to the management to cooperate with the RP. And it is a game of calculated risk. Diverging the records could implicate them further, whereas withholding them poses no threat. So my recommendation is that this section should be stringent with the penal provision. Only with the enforceable penalties we may ensure the compliance and cooperation from the erstwhile management of the CD. Not able to hear you. So these are some of my concerns and the suggestions which I have shared with you, and thank you for your attention.
Reshmaji, actually you have not differed with me. I'll say you have supported me.
How?
Yes, I tell you. What you have said that these applications are not given priority. I also said these applications are not given priority, and there are reasons. If the bench has to choose between a resolution plan application or avoidance application, benches are giving priority to the resolution plan applications. And that is why no priority has been given to avoidance application. I also said the same thing. I also said that because of this delay, why the delay is there? Because there are a number of respondents and the non-completion of the pleadings. That is why these delays are there.
You were saying that there are 40-50 respondents, Madanji. In case there are 4 to 5 respondents, in that case also the application is not decided upon. If it is clearly drafted and number of respondents are less.
When number of respondents are more, number of pleadings will be more. Pleadings will never be completed. Because all these respondents are either the directors or their relatives or their associates or their friends. They will never, their lawyers like us and Nipunji will never allow our clients to complete the pleadings. Once pleadings are not complete, matter cannot be heard. And unless the pleadings are complete, how can it be decided? These pleadings cannot be decided.
Yes,
that is why, Madanji, I suggested henceforth the only details is information system, management information system, and these flow of cash flow monitoring system in the bank through banks, because all transactions are happening. For future, we can certainly suggest to the government that the banking authorities, they are disbursing their money, they are disbursing the public money. So that is the first stage is that there. Or as far as the delay or these aspects are concerned, there is I have already suggested a number of forums that the adjudicating authority and the company benches, company law matter, they should be separated.
Sir, I appreciate this, sir, because we have given this suggestion and Manisha is witness to that. We have given this suggestion to Honorable President NCLT that at least company law matters, there should be separate benches. And because of the lack of infrastructure, we have not been able to have those benches for company law matters, what to talk about separate benches for avoidance applications? That is the least priority. And we were not going to witness the separate benches for the avoidance applications.
Actually, Natalji, moreover, I think the kind of tenacity that one needs to look into avoidance transactions in such short time, it's because itna pressure hai ki, when it comes na, generally it is the last resort. And there is so much of Gupta ji is here. We are so fortunate. Gupta ji would note there are 100 respondents. Okay, RP doesn't want to leave anyone under the sun. So when there are 100 respondents, imagine Gupta ji, aap bataiye how much time it takes.
That is what I'm telling. There is one structural, another reform is needed, which I met the MCA people whenever I had the occasion. But NCLT rules are not effectively taking care of IBC because they are in a particular direction, and IBC needs a separate rules, which need to be framed as a AP.
Sir, it's a criminal. It's a criminal trial where there are 100 accused and criminal trial.
No. I'm saying just coming to that. First of all, for all delays, not only relating to this, and there should be separate rules for IBC, including the taking care of this aspect. The other thing is, as it is being said that the limitation period be extended, look back period, sorry, be extended. I agree, but what is happening? What we observed, if the out of the jail or you to prove to come into the good books of COC, there were instances where the transactions were brought in section 66. All the transactions are brought in section 66. There is no look back period limitation. So without meeting, and COC recommends that. Okay, they also want to clean their hands. We have done our job.
And now that's also not practical. That 66 is also not practically possible nowadays.
Not possible. So 66 may be limitation. Ani chahiye ki there should be. We have seen, to be very frank, we have seen that certain applications from the face of it have been filed for the sake of file. So this additionally burdens the bench. So at least RP and the advisory or COC can help the bench in that sense by not filing the frivolous applications. Just like in income tax, what has happened, the tax effect is given. If beyond that, no appeal will be filed to ITAT or to the High Court or to the Supreme Court. So there should be some threshold be designed whereby some transactions having regard to the overall volume of the business or the loan should not be filed to reduce so that the quality is not compromised in the quantity. For the quantitative analysis, quality should not be purpose. The recovery should be substantial because the cost of recovery is also huge.
Sir, you have caught the bull from the horn. I tell you, because you said in majority of the cases, these applications are being filed for formality's sake. If you do not file it tomorrow, you have to report to IBBI.
That's all.
IBBI questionnaire may have you filed. When did you determine and when did you consider it? When did you file your application? Just for the formality's sake, the majority of these applications are filed for that.
Sir,
exactly.
There has been an example.
Just only one thing I have to add, that 66 mein what we were dealing with, there are two provisions, 66 subsection 1 and subsection 2. Section 66 subsection 2 is in addition to section 66(1). So when the application has to be filed in, if you RP has filed only 66(2), then he cannot make parties other than the directors who were handling the corporate debtor at the relevant point of time. So there is a fine difference between two proceedings, and both the proceedings. So that is also there. Supreme Court has not said that you cannot file the applications against the third parties. So 66(1) mein you can approach any party who has been part of the transaction. 66(2) management. So that we have to take care. So, but ultimately, look back period has to be refined. Threshold limit should be there. And another thing, but we have to simultaneously, another important suggestion which I can make, ICFR auditors have to report internal control and financial reporting regulations under Companies Act. So similar way, the related party transactions are being reported in tax audit and other things. Similar way, A column should be made as a part of routine, because now NFRA is hunting the practicing chartered accountants in a manner that they want to bring in discipline. And we should not forget the statements by Honorable Prime Minister that he is going to take hardest decisions in the third term. कड़े निर्णय किए जाएंगे. As we know his track record, be prepared. So many things are going to happen for which the groundwork has already been laid down at various levels of government, since we interact with the bureaucrats and other senior consultants. So he is going to, and he's saying 1000 years. It will be a foundation for 1000 years. So these statements are very clear. Every person has to act responsibly in the national interest only. And all these changes, perhaps which I am discussing, will be there sooner or later. The bankers will not be allowed to sideways by disbursing the money. It will be a track record will be of every trail will be kept. So transactions will come out automatically. Fraudulent transactions will be negligible, not substantial like the past.
Thank you, sir. Now, sir, Nipunji, please, for your comments. And please take over the session ahead.
Thank you, Rashmi ji. And I see so august speakers here. And it helps me a lot when I am at the last, because most of the part is already deliberated. Just 2-3 things. Fortunately, I was also part of this, which is now coming up, of the regulation of the expert committee on this avoidance transactions, wherein it is going to come up that there is going to be a form, what are going to be the ingredients, who are the affected parties, everything would be there in a tabular manner, because everybody from the judiciary side has been complaining that the forensic applications are in such a manner that those applications are not fruitful even for the adjudication purposes. I think Praveerji, would you like, are you sharing something? Okay.
I think by mistake, yes, then you can continue.
So some few of the things which were before the committee and which are also a bone of contention for all of us as a practitioner, also as an advocate or an IP. The first issue is that NRRA sale, which was permitted by the regulation, but then NCLT Delhi bench said that you can't sell the NRRA. You cannot sell it until it is adjudicated. So that became a bone of contention, and for mostly, I think, 6 to 9 months, most of the applications wherein NRRA sale was done got stuck. So now this has been resolved by the recent amendment. I think 2 days back, the amendment had come up. So this is now resolved that even you can sell NRRA. And mostly, what is NRRA? It is nothing but the bunch of PUFE applications. So that is something which is going to put some push in the pending matters wherein dissolution can't happen, even though the assets have already been liquidated. However, the same thing in CIRP is still before the Supreme Court. So all the 3 issues are still pending, and I will leave it to the House to deliberate their views. One, whether PUFE applications like the one in DHFL case can be sold at ₹1 at a notional value. Second, suppose in that case, I think around 40,000 crore or something PUFE applications were there, sold at nominal value of 1, and it is approved by the COC. So other stakeholders objected. Now, suppose, let's say it is got adjudicated and valued also. What would be the value of that unadjudicated PUFE applications which are pending? Because CIRP we have to close down at the best in 330 days. Application, as rightly pointed out by other speakers, that 75th day, 135th day we file, we create an opinion. But adjudication never takes place in this limited time period. Sometimes it goes on, and sometimes it gets stuck. Third, and very importantly, Honorable Gupta ji pointed out about the Supreme Court order. That Supreme Court order, and I suppose I would request Mamta ji and Madan ji to also deliberate with regard to Gluckrich Capital Order, which says that now NCLT does not have jurisdiction against third party. And for those third parties, recovery, you will have to go to the appropriate courts. maybe civil court, maybe criminal court, as the case may be. So my reading of that Gluckridge Capital judgment, and subsequently, I think 3-4 more orders have followed it. And now NCLT and NCLATs are following the order. So now Section 66 as such, we cannot file it against third parties. So now it is limited to promoters or probably suspended management. And if possible, related party. Again, it is debatable because related party may or may not be considered as a third party. Now, recently, in fact, today only, I was arguing one matter on Section 66, wherein the allegation is that promoter is alleging on Mr. X and Y that they have siphoned off money from the company. On the basis of his FIR, Section 66 is also filed. Now, in Section 66, technically third party goes away because of Gluckridge. Who is responsible? The suspended management. And suspended management themselves have moved an FIR. So this is going to be a paradox for everybody, whether it is suspended management or whether it is liquidator or RP. And I don't know how NCLT will get into this type of transactions. One more recommendation or suggestion which has come out is that there should be a separate bench to deal with it. I think separate bench does not solve the issue. The issue is possibly being solved by the special court. So we already have Section 236 wherein special courts are there, trials are happening. If there is an opinion that there is a fraud, only the special court has the power to take cognizance. Assuming NCLT take cognizance also, they will not be able to go for the trial. So specifically when they are already in lakhs of Section 7 and 9 are pending, resolution plans are pending, burdening them again with something for which ultimately trial could be easily quashed. I don't think so that NCLT is appropriate forum now for all these type of transaction. And one more interesting issue, which I just want to share with you all, the judgment of Gluckridge Capital of Supreme Court is only for Section 66. But now, in fact, me and various other lawyers are arguing before various benches, it is applicable and akin to preferential, undervalued and extortionate also. Because once the Supreme Court forms an opinion that there cannot be a jurisdiction on third party, it is not like it is only applicable to one type of fraudulent transaction. It should become applicable to all the avoidance transactions. So that is again something which is an evolving law and which is probably going to come up. Another issue, and which is more important with regard to forensic audit, I have seen.
Has any review application has been filed against
No,
this
sir.
order
Sir,
by the IPBI or something?
So the sequence is first the order was there, then a review was filed, review confirmed the order, then again another application was filed in another matter, referring that that review does not cover this. Again, it was confirmed. So now it is 3 times confirmed by the Supreme Court. Gluckridge is now the law of the land. Until a larger bench takes up the case, that's a different issue.
Or Section 66 itself is amended.
Probably, but
sir, 66, I think 66 takes care of sufficiently.
The
but
only
we don't know how
forum
the
would change. I think forum would change. It will now have to go to special court. There is no problem in the section. Only the forum will change. So it will not be NCLT, it will be special court. And I have been told, so as per the official data and probably the data which was available to us in the committee, that there is 2 lakh crores stuck in only PUFE transaction application.
38,000
2 lakh crores.
2,38,000 crores.
So 38,000 probably maybe our latest
further addition.
Yes. So my data which was available to the committee was this. So I think that is going to be a very big challenge as far as this issue is concerned. Another issue, and probably which I suppose all the IP should do, is try to, no doubt there is an order of NCLAT now that a combined application can be filed and can be prosecuted. But my suggestion to everybody would be try to break the application, because the bulky the application, the bulky the respondents, the adjudication becomes very difficult for the bench. So bench also does not get the readily available data. So that is also.
Nipunji, but Supreme Court judgment says that the separate application should be. So how the NCLAT judgment could prevail over the
Supreme Court order does not say so. We don't have time, but otherwise I would have taken you to the order. NCLAT has clarified the Supreme Court order. Supreme Court order nowhere says separate application. It only says that the ingredients of a particular section should be satisfied in an application. It does not say there should be a separate application.
No, that is where the Supreme Court has said that if you are filing even one application, all the matters, you should not write 43, 45, 50, 51 or 66 simultaneously. So you have to bifurcate the transactions according to which sections you are applying, even if one application you are filing. It cannot happen that you use all the sections, because that is ingredients of all sections and reach and operating field is different. So that you will have to take care. Otherwise, in my understanding, you will be violating the Supreme Court judgment also.
So, sir, what you have rightly said, that we should put a section and the ingredients.
We
But
should do the segregation section by in that application. 43 one at one place, 45 is another place, 51 is another place, 66 is another place. That you can do.
Correct, sir. But now the problem is the judgment which talks about this, that is the JP judgment. If you read the judgment,
JP Infratech versus
the allegation of the forensic auditor and the RP was that this particular transaction is fraudulent, whereas Supreme Court held it to be preferential. Now, what will happen in such a situation? Now, if I draft an application and make a prayer that this is a fraudulent, in the alternative, it is preferential. Court will throw out my application on the day one. But court has adjudicated it otherwise. So again, this is something which is as of now not clarified, not adjudicated. And obviously times to come, this will get settled. But as of now, what issues I think were there? One was this NRRA sale during CIRP and after CIRP and the benefits. So the benefits is also one thing which again, I suppose has to be valued. So as we value the land building, plant machinery or financial assets, I think PUFE application should be valued, should be assigned an X price, and then only the plan should get through or the auction should get through. Otherwise, this is going to be a Pandora's box. No end will come onto these particular situations. So I think
that's a very relevant suggestion, because it will also give the management or the owners, erstwhile owners, a relief in their personal guarantee case. Because the more is the realization, they cannot be made to suffer twice for the same amount.
Sir, since you have touched upon it, it's again a very big issue. So if there is an interim moratorium, can PUFE order be implemented against the promoter? So that is one issue which is still not clear. Second is, if the insolvency of the personal guarantor triggers, there is a concept of excluded debt. There it says, if there is any breach or contravention of law, it gets excluded. So now PUFE is absolutely breach of law.
Breach of law.
So then it gets excluded. So then what is the purpose of personal guarantor insolvency? It's again a very big question. I had written a paper, it just got selected. So that issue is still there. I don't know how it will get resolved, because in the Indian setup, we all know that every bank, whoever gives money to the company, takes a personal guarantee. Without personal guarantee, there are no loans in India. So that is going to be a very big issue, how this excluded debt will come up, and it will be adjudicated during the process of personal guarantor insolvency. So
one question I have here, like my sense is different. Is the individual insolvency a better course for going against this PUFE, or it is a bad course? Like once you locate some PUFE transaction, so should we go to the individual insolvency, or should we not go to that road and go to some other course? I need your opinion. So I have opinion that personal insolvency is directly against this, so you lose money here. Your opinion.
My view is that, sir, personal insolvency, if the promoter is not litigating, it's the best thing to put an end to the debt. Otherwise, that debt will.
But then he gets a discharge, no? Basically, 2% he gets it. So even if he is having thousands
so I was on that point, sir. I was exactly on this point, that the excluded debt concept says that even if the insolvency and resolution takes place of the personal guarantor, that excluded debt will still persist. So he cannot get away. So I cannot do a economic crime today, go to personal insolvency and get discharged. That excluded debt will still be on my head. So I'll just share an interesting incident, because you have touched upon it, and it's again of Mumbai. So what has happened is, and I am not disclosing the names. Personal insolvency of a very big, rich person has happened. His companies are already under insolvency. Now, personal guarantor insolvency has happened, and he was supposed to lose his home because 10 lakh, 20 lakh is nothing in today's times. Now, just before that, when he was aware that this is going to go away, husband and wife live in the same home. Wife files a case, gets a consensual order that she will be given one room in that home. Now that cannot be sold because that order is binding. The excluded debt says any order of any court with regard to maintenance law is excluded. So that cannot be sold. So again, these are ways and means where people will come up, and probably for times to come. And Madan sir is, I think, smiling on this. So probably some more plannings will come up. Let us wait and see what will happen. That's all from my side.
So, just on a lighter note, it also happened in as to have an advantage of gifts on the occasion of marriage. People used to marry, take substantial crores of rupees as gifts, free under Section 56, and after 1 year they took divorce. After financial year changed, and they divorced. Money is taken. So such kind of innovations you cannot plug all. The defaulters will always be more smart than the legislators.
Correct. And sir, you are only talking about one spouse, I understand.
Pardon?
You are only talking about one spouse.
UCC हम लोग के लिए तो वैसे now UCC is also come.
So I think Manoj Kumar Anandji, will you like to join and give your views, sir?
I'm really sorry I could not join the meeting because of all of a sudden something happened in my office with my clients. So I get involved there. So I just joined hardly 2 minutes ago, and since I'm not part of the discussion, I'm not much aware of it, what has been discussed. So kindly excuse me for that. You're talking about the personal insolvency. I heard only for the last 1.5 minutes only. You're talking about the personal insolvency. I agree with you that this personal insolvency law is, despite recent judgment of this Jajodia or Gurmeet Sodhi, the things are being crystallized. And another thing I'm finding is that with the passage of time, if Section 94 application is being made, then creditor files an application under Section 98 for removal of the IP. And if 95 is made, 94, debtor is going for the removal of the IP, because it is happening that if the IP is appointed by the financial creditor, Section 99 report, little bit or maybe fully get tilted in his favor. So let's see how this our personal law as far as these type of transactions, although get developed with the passage of time. This is I have to add, as an extension of what you are saying.
So it is already 8:40. Yes. Can we wind up?
Yes. So, Mr. Praveenji, would you like to give closing remarks? Or if anyone is left, we can invite him or open the house for queries.
Sure.
Praveenji, are you able to hear us?
Yes.
Sir, we have completed the discussion.
Okay.
So now either we can conclude or open the house if there
Sir, my one suggestion is that there should be a provision for on Surfacing Act that there will be a cap for admission of claim. As I think 1 CR to be kept on that account, so that insolvency objective is to be fulfilled. IBC code objective to be fulfilled. Despite every cases are going to be in surfacing, not going for IBC. And I was seeing that in south region more cases are coming, but not coming in north region.
Correct, sir.
So there should be
just
some
one more
sort
thing.
of
I
action.
would like to add that there should be some clarity on the mutual set off of the transactions for PF also, for moratorium purpose also. Because if one has to pay, one has to receive, that differential treatment is given, and that is not equitable.
Yes. Any other participants may speak to something, please.
Nipunji,
Preeti
like
ji.
you said, कि मतलब fraudulent transaction should be valued, but who will value those मतलब PUFE transactions or avoidance transactions?
So that is again going to be $1 million question, because a person who is an IP and a valuer will probably be in a better position to say what is possible. Otherwise, it is going to be a very big headache. We are seeing it around 40,000 crore PUFE of DHFL sold at rupee 1.
Because seeing the court, matlab, if NCLT is not able to decide on those things and they're not passing the judgments, and those, I don't know what will be the, outcome of any of the legal facets पे क्या होगा.
रश्मि जी, NRRA बायर ही इसकी वैल्यूएशन करेगा बेस्ट, जो अभी निपुण जी ने बताया आपको. और मैक्सिमम ट्रांसैक्शन यानी कि लिक्विडेशन के टाइम पे NRRA के पास ही जाती है.
हाँ.
If any other question of any
liquidation
participant.
में है ना, मतलब वो CRP में भी can we assign the debts?
No, we can't assign. No.
हाँ.
Sir, my question to Mr. Nipun.
Yes, sir.
Sir, you are coming up with one format for avoidance applications.
Yes.
What will improve the present system of the avoidance applications?
So basically, the format will give the data and the ease to the adjudicating authority to adjudicate faster. That is the whole purpose of this format, which is probably going to be out. So this particular format only says what is the section, what are the ingredients, what would be the reason that this is being considered to be, let's say, preferential or undervalued, what is the parameter basically, and the allegations. Otherwise, what is happening nowadays, the report runs into number of pages. The content as per section is not captured. So this is only for ease and convenience. The pleadings will continue, but this is just like we have Form H. You create the complete IA for resolution plan. You put the resolution plan, but Form H only gives a bird's eye view to the adjudicating authority. So ultimately, this is only for convenience of adjudicating authority.
Thank you, sir. Thank you.
Sir, without cooperation of CDA and creditor, how we can compliance is made with respect to executing authority or forensic audit valuers without any information? Yes, sir.
परवीन जी, हम आईपी बने इसीलिए हैं कि अगर कोई कहीं से कोई कॉपरेशन नहीं आती, उसके बावजूद भी आप कर लो. आई जस्ट शेयर वन टेल विद एवरीबॉडी देयर. एक बार मैं सीओ से मीटिंग कर रहा था, तो वो जो वॉल के ऊपर पंखा होता है ना, वो नहीं चल रहा था. तो मैंने वैसे ही हल्का सा हाथ लगाया तो चल गया. तो एवरीबॉडी इन द सीओ से मीटिंग सेड यस, दिस आईपी इज सो proficient to give solution. So we cope up with all these things and we learn with the passage of time. और अल्टीमेटली कर लेते हैं हम सब लोग, चाहे कहीं से भी कुछ भी कोऑपरेशन ना हो, वी कम आउट विद द रिजल्ट.
सर, अपनी पोजीशन तो वही हो गई कि ट्रांजिस्टर होता था, अगर नहीं बोलते तो थप्पड़ मारते थे उसको और वो बोलने लगता था.
अरे मनोज जी, ध्यान रखना, कहीं उसमें लाइव वायर होगी तो करंट भी लग जाएगा.
चलिए सर, शहीदियों में आजकल
I have to go somewhere. I thank everybody at
Sir, before you go, I just humbly submit to everybody that we are holding tomorrow also a webinar whereby Mamta ji is a speaker, and this is basically based on जो भी ये recently CRP और liquidation के दो आए हैं, which are very material, along with 2 notifications issued by there.
Tomorrow I am traveling.
Okay. I request everyone else कि हमारी आईपा और जीपा ही इसको होल्ड कर रही है, as comfortable to join that seminar. 4 बजे का है, लिंक हम आपको भेज देंगे.
Just भेज दीजिएगा if I could connect. I will be the beneficiary.
I know, no, sir. We will benefit with your presence. Your presence is always highly motivating to us. और ममता जी को
Thank
तो
you so
वैसे
much.
ही
I feel
बहुत
privileged.
ज्यादा
I feel
वो
humbled.
होता है आपके लिए। ममता जी आप
Thank
बहुत
you
ज्यादा
so
चले गए।
No, she just left for the meeting. She has another meeting, so she has left.
Okay. Now you can.
Now we can conclude now. Nipunji, please conclude and take a vote of thanks.
Sir, I have one question.
Okay, please.
Even if the transaction audit report is there, I could not give him the money trail because I don't have it as RP. So how to find that money trail, either through bank or through cash transactions, how to find that money trail? Because without that, the transaction audit report is of no use for me.
Is it to a specific speaker or everyone? Vaishali ji?
Everyone.
Audience.
Anybody.
From audience.
Right. I think I can respond if anybody would like to add something. So Vaishali ji, if the allegation which is prima facie opinion of the forensic auditor is not backed by the evidence, what you are saying, if the trail is not there, court will not get into it. Because until you bring some evidence, court will not get into it. At the best, you can move it under non-cooperation that these documents are not there. Prima facie, it appears that there is some hanky-panky. At the best, there could be directions from the court to produce it. In fact, I tell you, in one of our case, after 2 years, continuously operated. Only by some PAN number, some TDS was detected, it was reflected, and then we found out. So CIRP over liquidation 2 years, and then we got to know. So sometimes it could be like this, but without evidence, if you go to court, court will throw away.
निपुण जी इसमें मैं थोड़ा सा ये ऐड करना चाहूंगा विशाली जी ये फॉरेंसिक ऑडिटर की प्राइम ड्यूटी है ट्रेल फाइंड करना we as an IP we can cooperate to him but it is the most responsibilities of the forensic auditor for which we have appointed him.
He says that we are only doing the transaction audit and you have to give the evidence that it is actually happened, that money in cash has been given or like that. Then only we will do this.
Vaishali ji, ये उसकी responsibility है वो he is unnecessarily passing on the baton to you but for then what purpose do you appoint the forensic auditor only to find
again
that...
sir the question of fees comes here how much you are paying you get that much in the report.
Yeah.
So if we pay very less amount you won't give you everything.
Yes, it was L1.
Yeah. So that is the basic problem.
Okay.
Yeah, can I add to this? As
yes,
Sanjeev ji has rightly mentioned, the money matters a lot in such cases. And second thing is there is a difference between transaction audit and forensic audit. So it is all depending on whether you have appointed for a transaction, then it's more or less you are supposed to provide all the information. And if we appoint the forensic auditor, then the ball goes to the court of forensic auditor to identify a lot of informations, their own. So, as an insolvency professional, one should be very careful that for what purpose you are appointing the professional. So, it is all depend on the whether you are going ahead with lot of transactions where you have probably, say for example, section 66, then you preferably one should go for a forensic auditor. But suppose if you have clarity on the entire financial statement and the operations of the corporate data, and you identify a couple of preferential transactions, then in that case you go for a transaction audit, not the forensic audit. So that's how one need to really understand the difference between the auditors and the appointment thereby. Thank you.
Yes, thank you.
So, Praveen ji, I think we can conclude.
Yes, sir. Yes, sir. Please. And take a vote of thanks.
Nipunji, one query to you. I just wanted to confirm if there are certain related party transactions and it is beyond the look-back period. Like transactions was conducted during 1819 and CRP admitted 23. Can we cover these transactions under section 66?
Yes, you can cover. There is no time limit for fraudulent transactions.
But it is two related parties, transfers to related parties.
Whatever it is, there is no time limit for fraudulent transaction. time limit is only for preferential, undervalued, and extortionate. There is no time limit for fraudulent transaction. And if you want some judgment, you can text me. I will send you 2-3 judgments. Many judgments have come on this issue. Section 66, there is no time limit.
Okay, sir.
One more question with Nipunji.
Yes, sir.
Nowadays, this NCLT in the NCLT while we are filing for dissolution applications, so they want the bank CEO's SEC member wants that avoidance transaction as well as NRI assets should be assigned or sold, but there is no marketplace available. We are finding it very difficult to file dissolution application.
Correct. So in that case, you will have to try and get it through private sale, because most of the NRRA, which at least I have observed, they're only sold through private treaties, because nobody technically comes in auction. Nobody is able to just see the auction notice and understand what is the amount and what is the probability they might get. So my suggestion is try for a private treaty and try for somebody who is going to be the most affected person in that particular bunch.
Is there any market available? Is there
as of now, no.
Sir, I can answer this. So we are working on this kind of transactions. I am especially in the Insolvency Law Academy doing a research paper. So there is some interest where, at least because in India, even if you locate the trail, it is very difficult to get hold of the assets. But if the money trail goes overseas and you get a court order, then it is a possibility that we can go after the. So I'm working on that kind of transaction. So there is a market. That is what I would say.
But matter will keep going on extension after extension. Nothing will happen.
So basically, what you need is some order from the Indian court, because any foreign court will only look for some order, some statutory authority which you have. Once you have that order, then you go after in the interest arena, and you have, because there the law is settled on it. If some money has been diverted through money laundering or any other means, then you can go after that. So you can be done.
Thank you, sir.
So I think, sir, we can conclude now.
Yes, sir.
Jain Saab?
Yes, sir.
So I am very much thankful to all the august panelists and the participants. It gives me immense pleasure that you all have been very active in all our webinars, and I look forward for the same cooperation in future also. And tomorrow also, as Manoj Anandji has said, we are having a webinar again. So request you all to join the same. Thank you very much for your wonderful support.
Thank you, sir. Thank you
to everyone.
Thank you, sir. Thank you to everyone.
Thank you, Nipunji. Thank you.
Thank you, everyone.
Thank you, everyone.
Nipunji especially.
Namaskar.
Thank you.
Namaskar.
Namaskar.